Carey on behalf of the appellant, Advantage Limousine, who I'll refer to as Advantage. At issue on this appeal are 4 errors by the trial court. First and foremost was that the trial court directed a verdict against Advantage on its claim against the appellees Olympus and Koutsos for aiding and abetting Keith Simmons' breach of fiduciary duty. In ruling on the motion for directed verdict, the trial court addressed each of the 4 requisite elements of a cause of action for aiding and abetting a breach of fiduciary duty. On elements 1 and 2, the trial court found that a fiduciary duty existed from Keith Simmons owed to Advantage, and secondly, that Mr. Simmons had breached that duty. On element number 3, which is knowledge of the breach by the aiders and abettors, in this case Olympus and Koutsos, the trial court said it was giving the benefit of the doubt to Advantage and assumed the breach by the knowledge of the breach by Olympus and Koutsos because of a cease and desist letter which Advantage's counsel had sent to Olympus and Koutsos, which included a copy of the complaint they'd filed against Mr. Simmons for breach of fiduciary duty.
Mr. Carey, I'd like to clarify 2 things, if I could, with you.
Sure.
The issue on appeal doesn't concern the result into count 4. That is the tortious interference with the contract.
That's correct. That's correct. We've not appealed that.
Okay. So this is only the aiding and abetting count, which is count 3.
Yes, sir.
And the violation based on the statute you cited were under 605.04091 was the appropriation of a company opportunity. Is that correct?
Yes, sir.
Okay. I just make sure I had the grounds level.
Sure. And in any event, motion for directed verdict, of course, it's appropriate to give the benefit of the doubt to the non-moving party, what the court did. I'm sorry, did someone say something?
I don't think so.
Okay, maybe I heard something. In their answer brief, Olympus.
Let me go ahead and ask you a question, Mr. Carey.
Sure.
Substantial assistance, this is what we need to focus on. And you rely on the Logan versus Morgan case and some similar cases that for the proposition that substantial assistance can happen after the fact.
Yes.
But I'm having a hard time finding that those cases are similar to the facts here, where that line of authority relies on more active wrongdoing in almost independent and separate from what is actually going on, but of course allowing the continuation of that fraud or whatever the tortious activity is. And so, for example, in Logan, you have the attorney opinion letter that's written knowing that there's this illegal activity going on. Same thing in I think it's the Gillison case, the car dealership, where you have board members of the bank that are accountants on the payroll of the car dealership. They're actively doing something that's wrong. And here, the Olympus and I think it's Koutsos, probably mispronouncing that, but here you have those 2 supplying vehicles. I'm not seeing the connection of some independent wrongdoing that they're doing to facilitate this corporate opportunity. Help me out there.
Sure. Well, that's the point where I guess the kind of the knowledge element merges with or intersects with the substantial assistance. If they had no knowledge and were not notified of the wrongdoing by Simmons, then absolutely, I agree with you 100%, Your Honor. But the fact that they had been put on knowledge by email, by letter, by phone call, and by text, and knew that this man was breaching his fiduciary duty, and he couldn't do it without them.
But did they? And I know the focus is on actual knowledge, and even general awareness, but not red flags. So here we have a conversation between the principal of Advantage and Olympus. And what he knows at that point is that there's a prior contract with Hard Rock that had ceased. And that he had this other business partner. Then we have a photo. We don't have the full document. So I guess the question is, are there some cases or something that says, hey, someone can't just simply turn a blind eye, or if there's these red flags that they have some sort of obligation to do some due diligence to make sure there's no illegal activity going on, and I'm just not seeing that. So tell me how that equates to actual knowledge.
They were put on notice, Your Honor. They were not only given the photocopy, but they were sent a copy of the complaint with it. One of the attachments to it was the contract that required the member, Mr. Simmons, to devote his exclusive efforts. So they had knowledge of all those facts because they were told them. Now, they did hear, admittedly, conflicting information from Keith Simmons, but what the case law stands for, the Camille case we've cited, and again, it's an analogous situation, but their subjective beliefs that they may have had are irrelevant. That's not a defense. If you look at the restatement of torts, section 28, liability for aiding and abetting does not require showing that the primary wrongdoing could not have occurred without the help. It's enough that the assistance knowingly provided made the primary wrongdoing easier to commit. They don't need to know all the facts. They don't need to know, appreciate the legal significance. They need to know the facts. And here they knew the facts. They were put on notice of the facts, like I say, and
put on notice, right? But they weren't they put on notice of the action that had already happened?
no.
Simmons had already created the company. Seminole had already landed the contract. They weren't instrumental in doing any of those things or further facilitating that corporate opportunity breach that Simmons did.
Simmons had landed the contract, you're correct, but who was performing, who was still servicing the Hard Rock account? Advantage. And the reason Advantage was, even after he landed the account, to use your words, is that Simmons could not perform. He absolutely did not have the ability.
Isn't that more of akin to a tortious interference of the contract rather than aiding and abetting the commission of the tort? Because if the tort, as you argue in the pleading, is the appropriation of a company opportunity, that arguably concluded when they got the contract.
But no damage had occurred. And
well, there's a breach of a duty. There's at least the law implies nominal damage award, does it not?
Okay, but one of the elements for a breach of fiduciary duty is damage. No damage occurred in this case because we were continuing to service the account until Olympus and Koutsos provided Simmons with the vehicles he needed in order to service the account. Up until that point, no damage occurred. The tort had not been completed.
Mr. Perry, one of the questions that I have about the case deals with the nature of the breach. The position of Mr. Koutsos and Olympus seems to be that the breach of fiduciary duty was a discrete act that was completed at the time Mr. Simmons got the contract with Hard Rock or solicited the contract with Hard Rock and failed to bring Advantage into the discussion so that Advantage could renew or try to renew its contract. It seems that your position and your client's position is this is an ongoing breach of fiduciary duty. It wasn't one discrete act. There were multiple acts. But you didn't cite any cases that discuss that. So help me understand that.
I go back to the requisite element, including a damage, and the breach is not complete until the damage occurs. The damage did not occur until Olympus and Koutsos provided the vehicles.
Well, there was at least a breach with damage at the time Simmons entered into a contract with Hard Rock and started providing some level of service to them. And I think there was a question of, it was shuttle service, and Mr. Advantage and your client understood that it was simply, I'll call it a one-off of some limited shuttle service. But isn't that at least some element of damage, even though your client didn't want to claim it as a damage?
No, Your Honor, let me clarify. A year earlier, Simmons had provided a standby vehicle, had nothing to do with the shuttle services. Okay. Then in 2016, what he did is he obtained the contract for the shuttle services. He was unable to perform. The evidence indicated that, and we didn't know about this, Advantage didn't know about this. Advantage continued to perform the shuttle service.
Is that
And
under an oral or a written contract?
pardon me?
Is that under an oral or a written contract?
Under an oral contract. The written contract had expired. They
Expired.
continued.
So under the oral contract, what expectation did you have of long-term future performance?
We didn't have an expectation with respect to Hard Rock, Your Honor, where the expectation was with respect to our business partner, Keith Simmons, who owed fiduciary duties to us. We did have a long-term expectation from him, and he breached that. But again, even though he breached that, and even though he obtained the contract, he couldn't fulfill the contract. And record indicates that Advantage continued to do so. The weekend before, he approached Kutsos and Olympus and was able to persuade them to provide him with the vehicles he needed to continue and complete the breach. And so the breach became complete. But just to make clear, what happened back in 2015 has nothing to do with this case. We're talking about the shuttle service in 2016. That is where the breach of fiduciary duty occurred. It became complete, and the damage occurred once the vehicles were provided. So that is the first error we have asserted on appeal. The second error is the denial of our motion in limine, allowed the jury to hear evidence and argument regarding a settlement agreement between Advantage and Keith Simmons. Florida statute section 768.041 subsection 3, evidence of settlement agreement shall not be made known to the jury. The Salibi case, the Florida Supreme Court has said there are no exceptions. No exception for bias, impeachment, or otherwise. It's reversible error to let the jury hear about a settlement.
Let me ask you about that in light
Sure.
of our Supreme Court's pronouncement that we are, to look at the text. Subparagraph 3 says, the fact of such a release, which arguably for the purposes of my question relates to paragraph 1, a release or covenant not to sue. It lists 3 areas of damages: property damage, personal injury, and wrongful death. If number 1 is the type of release that they are referencing in subparagraph 3, the damages sought in this case do not seem to be covered by the text of the statute.
Case law, including
I'm
this.
not worried about the case law, because
Okay.
they've told us now it's the supremacy of the text, and that's what we are supposed to do. Whether that challenges all the other opinions that they've written is another story. My question is, if I'm fulfilling my obligation and I look at the text of the statute and I have to write an opinion about it, do I write about what the statute says? Do I interpret that? Is that a correct interpretation of the language appearing in the text, specifically paragraphs 1 and 3? If it's not, then that case is fine. If not, if that is a correct understanding, then we may have a problem there, and maybe a question has to be certified. Because we're now what, a supremacy of the text? Isn't that what our Supreme Court has told us?
I think you could reasonably interpret the text to preclude the admissibility of any evidence or any argument concerning the settlement agreement consistent with what courts have done for the last 15
What does the word
20
such mean? Because they could have just said the fact of a release or covenant and omit the word such, and that would be any and all. The fact of a release or covenant shall not be known by the jury. What does the word such mean? To me, I think there's an argument that we construe such a release within the confines of this section of the statute refers to sub 1, a release not to sue on those 3 areas. That's an identifier. but I don't know if that's correct. That's why I need your commentary, because once you leave, I don't get a chance to ask you, give me your view of it.
No, I understand. I appreciate that, Your Honor, and I think that it is correctly interpreted as prohibiting any evidence or any argument concerning the settlement agreement, the same as the courts have determined for the last 15, 20 years,
Okay, got it.
with no exceptions. And so anyways, there's this.
Mr. Carey,
Sure.
what about section 46.015?
I'd have to pull that up and look at that, be honest, Your Honor.
That statute doesn't seem to have the same limitations as far as damages that the other section 9408. I think I've got, I'm sorry, 768-401. 768-401 seems to be, as Judge Casanova pointed out, limited to tortious conduct resulting in property damage, personal injury, and wrongful death. But 46015 does not. So does 46015 apply or not?
I think they both apply. And I think the evidence code as well applies, that prohibits any evidence of a settlement.
Although
The
the evidence
evidence
code,
Go ahead, Judge Silverman.
although the evidence code also provides for use of information for purposes of impeachment, that was pointed out in the dissent by Justices Kennedy and Polston. But those were dissents.
I understand.
Well, let me go back to 90.408, which I believe you also cited.
Right.
It seems that that statute has a limiting provision. It says it's inadmissible to prove liability. Would it not be admissible for other valid evidentiary purposes, such as impeachment or other things, which would require some sort of either a limiting instruction or a use only in a severed trial on the issue of liability, so it doesn't come in, but if it comes in on damages for impeachment, the statute says inadmissible to prove liability. It seems to me as a very narrow application.
I would agree with that, but you got to read all the statutes together, Your Honor, and I think all the statutes together, it prohibits this, as the Supreme Court has held, with no exceptions.
Yeah, I need to tell you, you got 3 minutes to go.
Okay, let me move on quick. So in any event, that was clear error. Then we have the error of the admitting into evidence a magistrate's finding regarding credibility of Hanny Banoob in an unrelated case 10 years earlier. She allegedly admitted on the basis of character or reputation evidence. The Florida statute 90.405, character evidence is admissible only when the character of a person is an essential element of a claim or defense. That doesn't apply here. 90.609, reputation for truthfulness. The foundation that's required for that is reputation for truthfulness in the community. We don't have this. We've got a magistrate talk about his perception in that particular case. The fourth and final error is award of attorney's fees pursuant to proposals for settlement. The proposals for settlement were ambiguous in two respects. First, they were expressly conditioned on the execution of both a confidential settlement agreement and a general release. The general release was described, the confidential settlement agreement was not. Under the Swartzel case, they said it's critical that what is to be kept confidential, who is covered by the confidentiality, the time period of the confidentiality, and remedies in event of breach, all should be either addressed in a written document or specifically described in the proposal. They weren't. So therefore, the proposal is ambiguous and unenforceable in that respect. Secondly, the proposals were ambiguous in that it was ambiguous whether advantage was required to release just the claims in the lawsuit or all claims between the parties. You had two paragraphs referring to just the claims in the lawsuit, three, and two paragraphs referring to all claims whether in or outside the lawsuit. And this is not an academic exercise because in this particular case, these people had different business transactions between them. There were farm in, farm out accounts where money was owed by Advantage to Olympus and vice versa. And so therefore you have an ambiguity created as to what exactly was being required to be released. So in bottom line, we would request this court reverse the trial court on all four errors we've identified, vacate the final judgment, vacate the attorney's fees and cost judgment, remand to the trial court for a new trial with instructions that on retrial, the jury is not to be told of the settlement and there's no evidence to be admitted of the magistrate's finding in the 10-plus-year-old case. Thank you.
Mr. Carey, I assume that you are hoping to have a rebuttal.
Yes. Oh, I'm sorry. When you said 3 minutes, I thought you meant 3 minutes with the argument before the rebuttal.
No, you were at 17.
Oh, okay.
Yeah, I'm going to give you at least a minute to go with the 5 or 6 seconds you got left, because I don't think you should be anyone should be left with nothing in the bank, so to speak.
Thank you, Your Honor.
Counsel, Mr. Fleming, you got 21 rather than 20. I like to make sure everyone gets the same amount of time. So
Thank you, Your Honor.
we will do that. And I have cleaned off the time so you don't start with his 19 minutes and 54 and running out of time. You're starting at 0, so you get to use it all. And as I said earlier, the floor is yours, counsel.
Thank you, Your Honor. May it please the court. Dan Fleming, and I do want to point out, just so nobody's confused, my associate Kevin Trageser is sitting here in my office. I just wanted to make sure his attendance was noted. My camera doesn't allow both of us to be on, but he's with me as well and participated in this appeal. This is Dan Fleming and Kevin Trageser of Johnson Pope on behalf of Appellees Olympus and Ted Koutsos. Contextually, I think it's very important. And I think one of the questions that was asked, I believe it was by Judge Silberman, you asked a question about the damages, and you heard counsel for appellant talk to you about the damages being the important element to complete the tort. And I think it's incredibly important to look at pages 22, well, 23 is the actual, that's appellee's brief. Appellant's brief, though, and it goes directly to your question, and this is an appellant's brief. Page 22, they list the elements of cause of action, and conspicuously absent in both descriptions, because it's the actual correct recitation of the elements of the cause of action. Nowhere do you see damages. You see, and this is from page 22 at the bottom of their page, this is a list of the elements of the cause of action. Fiduciary duty on the part of the wrongdoer, breach of fiduciary duty, knowledge of the breach by the alleged aider and abettor, and the aider and abettor's substantial assistance or encouragement of wrongdoing. There is no reference to.
Interestingly enough, Mr. Fleming, in the restatement of torts, it does have damages as an additional element. It is interesting to me that the case law that is cited in the briefs doesn't address that, although it seems to me that damages has to be implicit, otherwise there's no basis for recovery. But I agree, that is not one of the listed elements. What I'd like to turn to is really the question I asked earlier. Judges Casanova and Smith addressed the issue of what breach and at what time frame. And the question I have is, at least if I recall correctly, what was argued to the trial court is there was a breach, I think it was in 2015, then there was another breach in 2016 when Mr. Simmons, or 17, when he formed his own company. And then it seems to me the question is, when he enters into a contract with Hard Rock, arguably, it seems to me that would be yet another breach of his fiduciary duty. And then the question that I posed, and I want to give you the chance to address it, aren't these continuing breaches? Once he actually starts servicing Hard Rock with limousines provided by your client, isn't that an additional breach?
And the answer is no, Your Honor. And that's because the case law specifically talks and distinguishes between substantial assistance. And the cases very specifically, Judge, talk about the difference between providing regular professional services as opposed to participating in the wrongdoing. And it goes to what Judge Smith was pointing out. You cannot find a case, and Mr. Carey's a good lawyer, he'd have it blown up for you, you'd have 50 copies of it. If there's one case anywhere that said that somebody providing routine professional services constituted nefarious wrongdoing, he'd have it. There aren't any. Every single case he cited for this court includes not only someone providing routine professional services, but somebody participating in the nefarious conduct, in the tort, in the wrongdoing. And going back to the original part of your question, is it possible for somebody to come in after the fact and then participate in that wrongdoing? I think it probably is, but you have zero facts of that in this particular case. And that goes really to...
Explain that to me, because the trial court found that the first 3 elements were met, or at least she assumed a knowledge element was met. And so the question is whether this is substantial assistance or encouragement of the wrongdoing. And so, again, help me understand, if Mr. Simmons could not perform the contract with Hard Rock without acquiring additional vehicles, and Mr. Koutsos is at least aware, potentially for a jury question, either actual knowledge or knowledge that is attributable to him, why would that not be substantial assistance to enable Mr. Simmons to breach his fiduciary obligations to advantage?
Well, because Your Honor, it has nothing to do with the breach. And I think you have to go back to when the breaches occur. And that goes back to your original question. When you look at what was done, Mr. Carey is trying to make the case that the breach could not have occurred but for the substantial assistance or the providing of professional services after the fact. And that's just simply not what the cases say. And more importantly, that's not a reasonable inference. Reasonable inferences have to go. Mr. Carey says it's an admitted fact. That's not admitted at all. Remember what happened here, Judge. There's more than 2 limousine companies that service the Tampa Bay area. Mr.
Yeah,
Carey's
we're not dealing with that issue. At least it doesn't appear the trial court dealt with that issue. And there was some testimony that only Olympus would be able to provide the limousines that were necessary to fulfill the contract. So I guess I'll go back to my point, which is if Mr. Simmons violated his fiduciary duty by entering into a contract with Hard Rock, but he cannot perform the contract with Hard Rock, that raises some other issues. But isn't Olympus's providing of the limousines enabling him to fulfill the contract with Hard Rock to the disadvantage of advantage?
Not without the actual knowledge that the law requires, Judge. And the actual knowledge is not what you have here. Again, what Judge Smith pointed out is correct, Judge. You're talking about at best in this instance. Remember the facts of the case. And it's important to understand, Mr. Koutsos and Olympus did not get involved in this. They were approached by Mr. Simmons, who told them, look,
I don't think there's any dispute about any of those facts. The question that I'm posing is the Honig case talks very specifically that a defendant must have actual knowledge of the breach of fiduciary duty, not merely red flags. But it also emphasizes, and other cases do as well, that if there is circumstantial evidence sufficient to establish actual knowledge, that's enough to hold a party liable. So, and in this case, wouldn't that be a jury question, whether all the information that your client got, was it credible? Did he understand it? Did he not understand it? He says, oh, I don't really get into the details because they didn't provide me a copy of the signed contract. But aren't those ultimately going to be jury questions?
No, Your Honor, because again, it's a reasonable inference relative to this knowledge. Mr. Carey wants you to understand that oh, look, there was no problem between Mr. Simmons and that's why if you look at their statement of facts, you see all these facts about how the rosy relationship between Mr. Banoob and Mr. Simmons, when the reality was, you got to understand, they initially didn't even sue my client. They sued Mr. Simmons for the breach of fiduciary duty, irrespective of damages. And by the way, this idea that there weren't damages before we started providing limousine service is belied by the record before you, which specifically states that back before July of 2016, Mr. Simmons actually diverted funds to another company of his, Estonka. I mean, those are damages that occurred. Whether they claim them or not for fear that they're going to run afoul of this case law doesn't change the fact. And if you look at Honig, and I think that's a great point, and I want to point out for the court here in relation, direct response to your question, Mr. Silverman, or Judge Silverman, is look at these 3 cases. The judge in this case, Judge Peacock, ruled on this case, and she very specifically said, and I'm reading from transcripts, page 689. This is her ruling on the motion for directed verdict on the aiding and abetting the breach of a fiduciary duty. She said, I'm granting the directed verdict on both of them. And on the second count, it's based on 3 cases, Fonseca, Honig, and Groom. In the appellant's brief, do you know how many times they mentioned any of those cases? 0, not 1, because if you read all of them in concert, not just Honig, but if you read Fonseca and you read Groom, you'll see that it's impossible to reconcile. What Mr. Carey wants you to do is to find that somebody providing routine professional services without the actual knowledge that the cases talk about. And you look at you go to all the cases that talk about actual knowledge, Judge Silberman, and you'll see that that is not what we have here. They've got at best mere flags. And again, it's a direct, and again, it's not a jury question because it has to be established. That actual knowledge, it can't be an issue of he said, she said. It has to be actual knowledge. It's not a question for the jury because that has to be established to get the breach of fiduciary duty. And again, going back to that, look at that. Not one of those cases mentioned in appellant's brief.
If your client sees a copy of portions of a contract with Mr. Simmons, between Mr. Simmons and Advantage,
Yes.
that is one piece of circumstantial evidence. Then you've got a discussion between the two individuals, which is another piece of circumstantial evidence. And I don't want to go through all the facts. Those were the two primary ones. But and then, of course, your Mr. Simmons said, "Oh, I don't have a contract," or whatever he said. Doesn't really matter at this point. But if circumstantial evidence can be sufficient to establish actual knowledge, why is that circumstantial evidence, if believed, not enough to establish actual knowledge?
Because it's not reasonable in this case, Judge, because in addition to the
Reasonableness, though, is a jury question, isn't it?
No, sir, not in this instance, because again, they have to prove actual knowledge sufficient. It has to be established. You can't have a jury question about reasonableness and say that that's something that we're going to prove later. Again, remember, this is the close of the plaintiff's case, and there is no evidence to establish any. Again, the facts that you're leaving out there, Judge, they're not just superfluous facts. In addition to Mr. Banoub's testimony is, look, he breached the fiduciary duty. Remember, Mr. Simmons' testimony is, yeah, I breached it, but I breached it because he's not paying me. So it would have been a reasonable breach. In addition to that, remember, we also have the facts that he went out and obtained. Sorry,
Mr. Fleming, so your client is entitled to believe Mr. Simmons over what the other side has said. Is that what you're ultimately saying?
I think the evidence in the case that was presented to the court, it's reasonable. It constitutes only mere red flags, which the case law says is not enough. What you're talking about, judges, in certain circumstances, there could be circumstantial evidence enough to establish actual knowledge. But in this case, where the facts are clearly in dispute, but it's not just between Mr. Banoub and Mr. Simmons. Mr. Simmons says he wasn't getting paid, so he had reason to breach. But in addition to that, we have the facts that exist that he formed another company, at least two companies. We have the fact that exists that he obtained a limousine license, and you have the pleadings that exist that the plaintiffs are operating under, the appellants operating under on this second amended complaint, Judge, that all these breaches took place before July 22nd of 2016. Look at the complaint paragraphs. I think it's 17 through 19 in the second amended complaint. Those are the operative facts that the plaintiffs proceeded to trial on, and every single one of them was complete by July 22nd, 2016. You know why that's so important, Judge? Because on July 22nd,
Mr. Fleming,
Yes.
Fleming. Okay. Are you saying that an aider and abettor can never be found to have aided and abetted after the fact, where they let's say they're somewhat familiar, you've got these red flags, and I think this is the point Judge Silverman's trying to make, but you have the red flags, and then you have some additional knowledge that comes into play later down the road that, hey, I've been given I had 2 things, but now I have like 5. I've got the complaint. It now shows, hey, look, I've got a copy of the agreement. Yet, you know what? I'm making money. I didn't know in the beginning, but I don't mind continuing to facilitate this breach because I'm being remunerated and profitably. Because I think initially, from what I understand the facts were, is that in the initial part, when Olympus agreed to help out, it was maybe one weekend. But then there came a point in time where it was all the time. And so you're not saying that even though a breach happened earlier, that an aider and abettor couldn't be found equally guilty of that if later down the road they learned all of the information. And I think on a directed verdict, if actual knowledge can be proven with circumstantial evidence, then if the trial court is supposed to deem that evidence in the light most favorable to the non-moving party, then shouldn't this have gone to the jury?
No, Your Honor, because again, remember, we're at the close of plaintiff's case. They put in all the evidence they chose to put in on this. And what you're talking about is a factual scenario that was not presented to Judge Peacock, because I think it's possible. The answer to your initial question, is it possible? Is it possible? Yes, I believe an aider and abettor could come in after the fact, participate in the wrong. And again, that's what all the cases, there's not one case that has been presented to this court, and certainly not a case that was ever presented to Judge Peacock, that states that anybody could be found an aider and abettor after the fact, which is at the best that they've got here, an aider and abettor after the fact without participating in the wrong, knowing of the wrong, and doing something affirmatively to this providing of professional services. That's why the case is distinguished between the two. If you look at the Meridian case, it talks about this. If you look at the Groom case, there's a distinct difference in every single case, as you pointed out at the beginning. Every single case that's been cited by either party, the only aiders and abettors of a breach of fiduciary duty that have been found and affirmed are folks that actually participated in the wrongdoing or had actual knowledge. And what happened here and what was presented at the close of plaintiff's case did not get anywhere close to constituting circumstantial evidence that should have gone to the jury. There's no evidence. Mr. Carey tells you that there's no contrary fact. Again, I want you to make sure, because there's an assertion in their brief that Judge Peacock did not discuss personal knowledge, and that's simply not true. As pointed out in our brief accurately, she very specifically talked not only at the trial level, where she said, she talks about in the ruling, after she talks about those three cases, none of which were responded to by at all in their brief. And then in the reply brief, they only mentioned Groom in one sentence and said it's an opposite. They didn't talk about it. I beg you to read those three cases, and you'll see you can't reconcile what happened in this case with an aiding and abetting of a breach of fiduciary duty. But going back to that assertion about Judge Peacock's ruling, she very specifically talked about knowledge. Yes, she said, all right, I'll give you the benefit of the doubt. But then she talked, and she went right to this point, Judge Smith. She went to the question of, what about this actual knowledge? Where are we? And she very specifically said, I thought we were going to go this far, allowing for the possibility that we just discussed, both in Judge Silverman's question and yours, Judge Smith. Can you get to a subsequent aider and abettor coming in and doing nefarious? Yeah, you think you can. And that's what she said. She did a great job of paying a close attention to that very fact. And you see it in her ruling, where she states, again, this is at page of the transcript, 689. She says, I think everything happened in advance of the fact. I think that we had gotten this far because I believed we might be able to show some other kind of knowledge. Going to Judge Silverman's question, was there going to be enough circumstantial evidence? Was there going to be evidence in the case from which anybody could even reasonably infer that my client had any nefarious participation in the wrongdoing? And the answer was no. And then she specifically said at the hearing on the motion for new trial, she said, and then there's all the cases you've presented to me. The players are all kind of nefariously involved. And I'm quoting, this is at page 918 of the record. And this is Judge Peacock. All the cases that you've presented to me, the players are all kind of nefariously involved in making that breach of fiduciary happen. And that's absolutely categorically true. You didn't show me any reason to believe that Koutsos or Olympus had that kind of knowledge. When you read those cases all in concert, you can come to no other conclusion but that sort of knowledge, that actual knowledge. It's a term of art, and it talks about having some sort of nefarious, some sort of wrongdoing. So you can't say, look, these guys, they were a dispute and it goes to the jury. No, you've got to have evidence in the case. Otherwise, you're missing a required element. And remember, I didn't finish my thought in response to Judge Silverman's question. Those dates are so critical. Every single alleged breach of fiduciary duty, not damages, and again, this is before my clients even knew Mr. Simmons' name. I mean, that is critical. You would be turning the law on its head to allow somebody to come in after the fact, didn't even know who the guy was, didn't solicit him, didn't participate. Everybody else who comes in after the fact, allowing for that possibility, Judge Smith, does so in a nefarious way. They participate, they promulgate the wrong, they do something, and that's clearly not what we have here. So I think, again,
FYI, you have about 2 minutes left.
I will very quickly talk about the other items. The proposal for settlement doesn't even pass the red face test. Very quickly, if you look carefully at our brief, you'll see where we talk about there's no other claims out there. There's no other claim. There's 2 accounts where 2 businesses owed some money. And if anything, my client had account. There were no other claims that could reasonably, and you talk about
Mr. Fleming, does
Yes.
the fact that the settlement agreement talks about a confidentiality agreement and does not describe any terms of the confidentiality agreement, any sanctions for violation of the confidentiality agreement, it doesn't attach a copy of the confidentiality agreement, why is that not problematic under existing case law?
address that very quickly. I'm running out of time. Judge, I don't think it's a problem because, again, if you read the entire proposal for settlement, excuse me, if you read the entire proposal for settlement.
I don't have any problem with the release aspect of it.
Okay.
Because the case law has already gone that way, saying that everybody pretty much understands what the idea of a general release is. But this settlement proposal also includes a requirement for a confidentiality agreement. And we have no clue as to what those terms would be, what is being protected by the confidentiality agreement, and what happens if there's a violation.
I think, Judge, if you look at the Nichols agreement, or excuse me, the Nichols case that we cite in our brief, and it specifically talks about that, and it specifically discusses that. Again, one of the things that is amazing in the brief, counsel relies on the decision, the Swartzel decision, and says it was reversed on other grounds. If you look at it, it was abrogated on these very grounds, and it was very specifically talking about this sort of language being nitpicked, and it's not supposed to be done. Judge Peacock followed the law to the letter. If you look at the Nichols case, you'll see that it very clearly covers that topic as well. It covers not only
didn't Nichols deal with a general release and not a confidentiality agreement?
I don't think so. I think it covers both. And I think if you read all, again, I would have to.
I'm looking at the opinion. I'm looking at the opinion right now, and the court seems to have focused on the general release language. So
well,
maybe
certainly focused on that, Judge. But I think it also dealt with the thing. I mean, again, if you look at the cases in total that discuss the releases and the confidentiality aspect of it, there is no ambiguity. There's no other reason, no other reasonable way to read these other than to determine that the proposals very specifically are unambiguous. They're clear. It doesn't, again, I don't think it even really passes the red face test. This contention.
Just so I can make sure we're on the same page, Nichols says, as a condition of the settlement, however, Nichols would have been required to execute a general release in favor of State Farm, which will be expressly limited to all claims, causes of action, and so forth. I don't think there was anything in there about a separate confidentiality agreement.
I thought there was, Judge, and I'm trying to look. I believe I would have to defer to my brief at this point for that part of it. But again, I don't think there's any question when you look at if you read the portion of the transcript where we discussed all these in incredible depth relative to both the 2 reasons he brought up were the same reasons he brought up. Judge Peacock considered them in full and clearly ruled consistent with Florida law on this topic, to basically allow this proposal for settlement in a case like this, where the proposal was sent and they literally filed this contention that there are these 2 accounts that somehow result in a contention that there's a prior claim and that therefore this is unambiguous or is ambiguous and not clear.
Just so you don't waste your time, I'm not worried about
the time is expired. I'm allowing him to respond to your question.
Well, then I will yield anything else on this. Thank you.
I'll have to defer to my brief, Your Honor. I know there's stuff in there about it. I just have to have time. I'm out of time. I would respectfully request that the court affirm on all 4 grounds. Judge Peacock was incredibly thorough in considering all 4 of these issues. Her ruling is in lockstep with Florida law when you look at the facts of this case every single case, there is not one that would allow anything other than a directed verdict and the recovery of our proposal for settlement fees as a result of this particular lawsuit. This is one that should have never been brought.
Thank you, counsel. I think we're done now.
Thank you,
We're
Your
at
Honor.
24, and I want to make sure that I balance out the time here. So, Mr. Carey, here's the good news. Since he took the extra minute I was going to give you and took 3 more, you have 4.
Thank you, Your Honor. Okay, may it please
You
the
only
court.
wanted 3, so maybe we should go back to the 3, right? Just to be safe. Well, you know, I'm going to make sure it's even. So, you can start with 3, but I probably will let you finish with your 4, just so I make sure that everybody's got the time.
I think it's important for us all to go back and remember the context in which this case is being decided, at least it's a directed verdict, okay? All doubts resolved in our favor, all inferences. And in this particular case, the issue that we've been focusing on is knowledge. And Judge Peacock found, that she assumed knowledge based upon the cease and desist letter. Knowledge is a fact issue. As Judge Silverman pointed out, it can be proved circumstantially, it can be proved by inference. So that is a fact issue. That issue should have gone to the jury. In terms of the substantial assistance, again, the evidence is he couldn't have done it without Koutsos and Olympus providing Simmons with the vehicles and the drivers. Platt couldn't have done it. That's the evidence in the record. In terms of, they had doubts. They were hearing conflicting stories between Keith Simmons and between Advantage, what they're being told. And again, they chose who to believe. Okay. Jury may find it differently, but that is
My question goes back
Sure.
to the language appearing in the pleadings and the requirements of aiding and abetting. And the knowledge said that what you pled, what the complaint says, is the duty of loyalty was breached from the appropriation of a company opportunity. And the opportunity was to have a contract to provide services. And that was appropriated by Mr. Simmons. Then it seems to be under the pleadings of this case, not in generally or hypothetically, under the pleadings of this case, it seems that that's a fait accompli. He got the contract.
but
That was the appropriation. Now we're talking about the performance of the contract. That sounds like tortious interference, perhaps. But we're talking about aiding and abetting in the commission. And the commission is the appropriation. And the appropriation of what? The contract.
okay. But
It
again,
seems like that's all done before these people come in.
we're talking about
It's not a continuing tort.
we're talking about a breach of fiduciary duty, Your Honor. Under breach of fiduciary duty under the Rocco case, which we cited in our briefs, the element of breach of fiduciary duty, the last element is damage, okay? And so while he
But
may
once
have,
he breached, the damages were suffered. You lost the right to complete the contract to get your
We continue-
only thing you needed left was the ascertainment of the quantity.
we continued performing the contract until Koutsos and Olympus provided him with the vehicles. We continued working for the Hard Rock. Let me just briefly address the proposals for settlement. The Swartzel case was not overruled on these exact same grounds. It was ruled because in that particular case, what the court held is you had to have actual copy, and what they said, the Supreme Court subsequently said, no, you can either do a copy of the agreement or sufficiently described it. As Judge Silverman pointed out in his questions, there was no description whatsoever of the confidential settlement agreement. And under Swartzel, that is fatal to the proposals for settlement. So thank you very much.
Thank you, counsel. Thank you both for hanging in and really responding to all the questions. It's very much appreciated. Without your preparation and skill set in doing that, I don't think we get as much out of the oral argument. So on behalf of the panel, thank you all very much. And I will let you, I guess, in cyberspace, transfer back to your point of origin. If you wish to listen to the remaining cases, that's your prerogative.
Thank you.
Thank you again.
Thank you, Your Honor. Now.